Today we are going to have a discussion on interplay on DPDPA and labor codes, how it is going to impact the business organizations. This is not only two enactments which are going to have a different working or scenario, but it is also going to change many dynamics in the business. To start with, I have Mr. Madhu with me. He will be dealing on employment laws, and we both will try to bring some intricacies discussed on the floor pertaining to data privacy and labor code. Over to you, Madhuji.
Thank you, Anand. So the context here is, as you rightly said, there is going to be a huge interplay between DPDP Act and the labor codes or the labor laws earlier, now with the labor codes where the companies or employers are trying to transition into it. Reason being, employers deal with a huge amount of digital personal data of employees, right? And there is an assumption that employee data can be obtained by the employer without a consent, which may be true legally. But then there are a lot of obligations that comes to it with for the employer. And then with the new codes and a lot of new procedures, a lot of new ways in which the data needs to be stored. The government is talking about keeping them electronic, keeping them online, and for compliance, making it everything digital compliance. Then there are a lot of interplay, not only between the employer and the employee's data, but also the regulators that they get all this data. But they all may claim exemption, but is that simple? Is one area of aspect that we will discuss today. And with that context set in, probably Anand, I will start to shoot some questions towards you.
Sure.
Right. So Anand, in the kind of employment life cycle of an employee, by the time probably it even starts before the he becomes a formal employee, right? When he is seeking employment, these days, most of the companies receive or welcome the CV, which contains almost every data that is there in the CV is a digital personal data. It has the name, it has the phone number, it has his mail ID, it has his address, whatnot. And from that moment, the data is with the employer. And till the time the data he is converted as an employee. Before that, there are a lot of process, right? It may come to you through a job board to the employer, and then he may look at what are the whether a particular employee is suitable or not. After that, he is called for an interview happens, and then finally he becomes an employee. And then the life cycle starts from a perspective of the employers collect that information as for various statutory purposes, for also his employer's own record, because he has to keep the records of all his employees. And then therefore there is this aspect of notice which is very, very important. That is notice to the person who is passing on the digital personal data, here the employee. And there is an aspect of consent which is mandated by DPDPA, which may not be required in this thing. But I would like your views on the employer's ability to use digital personal data of an employee, what is called the legitimate use provision. And then probably we'll kick off the discussion from there and then go to the next aspects of this interesting topic.
Yeah. Madhuji, in fact, thanks for setting the context. And this is actually a tightrope walk, what we can all make it out. If I will talk about the data privacy, I mean, under the Section 7 of DPDPA, it allows for certain legitimate uses regarding employment. So the employment is not that you have given an employment so you can use the data, whether the biometric or any other data which is resulting into identification of a person, whether it is prior to the employment or during the employment or after employment. So there are three phases. And even if I will talk about the first, where the lot of people you are interviewing and you're not employing all of them, then too the data is there and all are digitized. It is not that gone are the days when every data was offline and we used to put it in the files in the cabinet lying for years. Rather, it will be digital data which will be lying in silos. So it will be creating a legacy, data
Right.
legacy, which is the very dangerous. Given that
Correct.
factor, and then during the employment also you can use with a legitimate purpose or the lawful purpose. But the mantra is data minimization. That and the most important thing is the specific purpose. If you will see, the law does not say specific or specified purposes. The expression used is singular, specific purpose. Had the legislation intended, okay, you can use it in for various purposes, then the word would have specific purposes. But it
Correct.
is a specific purpose. That means a purpose has to be understood, interpreted, and implemented in that way that it is only for one purpose. So that
Correct.
purpose has to be, the responsibility is on the employer to check that whether it is meeting the requirement of the law, and if it is so, in what manner, whether it is resulting in the legitimate purpose or the lawful purpose. One example I should definitely put it here, which is very important and a lot of people are yet to realize it, is the employment contract does not give you that you can send or can share this data with anyone. If I will talk about one very sensitive thing, the payroll outsourcing, that is the
Correct.
requirement also or the compulsion, whatever. But for the purpose of an employee and employer, whether the person to whom the data
Yes.
has been shared, even for the purpose of, disbursing the salary, whether
Right.
that person can be considered at par with an employer,
Yeah.
unfortunately, it will be no,
Right.
because it is a relationship between an employer and employee. So the person to whom you have outsourced, that will be the third person. You have to take a proper consent. You have to do all which are required in the law. So you have to take care of those things. And also the third factor, if a person has left a company, then whether that data is required under the law,
Right.
then it's a different thing, maybe for case or maybe some other requirement for a specific purpose that you can justify. If you cannot, then you have to delete as the law provides. So this is all on this particular issue. But definitely, Madhuji, one thing which comes to my mind is uh, that person, I mean, this will be a culture which has to be set, and the companies have to be very particular about that how the data will be managed, and all these phases are equally met also.
Absolutely. I think well put. So from a perspective of receiving the data even before employment where you don't have an exemption or the legitimate use probably, but you can still probably an employer can argue for the employment purpose only I took it to interview him and whether he's suitable for it. While that there may be a legitimate use from a perspective of obtaining consent, but the employer is a data fiduciary as per the DPDP Act. And the employee continues to be a data principal. Whether he may be an employee, but he is a data principal because it is his data which is being obtained. And unfortunately, I think the employers are not yet woken up to this fact that this employee as a DP has his own rights. As you rightly put it, yes, for payroll purposes, it can be passed on to another data processor who may be a payroll administrator for the employer or to a HR service provider, probably where that data is required to manage the HR online services that the employer has been providing. All that is okay, but the employer remains the final person responsible to keep the digital personal data of an employee who is a data principal safe. I ensure that that doesn't get leaked. And if there is a leak at all, then there are onerous responsibilities about informing the board about it, and then how do we do about it? How do we go about it? And the right to erasure. I just wanted to add a point. It could be not only from a future dispute which can arise, let's say, it is also from could be from a fact that, for example, Income Tax Act requires the data with regards to, let's say, tax reduction at source, etc., to be maintained. From that perspective, you can keep it. But while keeping so, the rights of the employee as a data principal is not kind of compromised. Is something I think you will also agree with me.
Madhuji, actually, there is a very interesting thing. The
Right.
DPDPA is not overriding everywhere. Rather, Section 38 of the DPDPA talks about the harmonious construction, that it will be working in a harmonious manner,
Right.
provided uh, there is a clash. So
Right.
given that factum, if there, I have to repeat again that if there is a dispute, okay, an employee has left on not a good note, then definitely for any reason or for certain other legitimate purposes also, or the lawful purposes also, or if I will say, okay, there is some issue related to PF, or
Correct.
where this company has to uh, arrange, I mean, carry out all the activities for him so that it is duly disbursed to him, even with the government. So those things are to be retained till the time it is there, and there is nothing that data principal right will be hampered. So this is, and most of the things what I have shared for the first one, so it will be applicable here also. But Madhuji, I will like to put a thing to you that because I
Just
see
before
that.
that, Rishi, this needs to be edited. I have to switch on the plug, otherwise I'll go out of charge. 1 minute.
Yeah, don't worry about it. We'll edit it.
Yeah, correct. So yeah, so go ahead, sir.
Yeah, Madhuja, I have to ask you a very
Mm.
important aspect because I see a great conflict which is
Mm.
brewing up between the DPDPA and employment, I mean, the labor codes,
Mm.
and more particularly, I will say the consent versus contract,
Mm.
right? So if we will see both the things, that is, one is the consent which is under the DPDPA and the contract that is under the employment law. So how you feel that, okay, particularly the consent baked into fine print, does the new act effectively kill the irrevocable consent clauses we see in most Indian appointment letters? What are your views on it?
Okay. So I think while harmonious construction that you talked about and the labor and the legitimate use, which is also statutorily provided in the DPDP Act for the employer vis-a-vis the employee's digital personal data, it is from a consent perspective, probably the employers could get that through the appointment letter on while signing the contract to be overtly careful about that and then gets the consent. But if you interestingly, if you look at the labor code, there are two aspects in which consent is talked about. It may be very unrelated, but I'm just probably relevant to this discussion. Where under the OSH code, to employ a person in overtime, the code talks about consent of the employee who is going to be employed overtime. Second, to employ women in the night shift, again, individual women's consent is required. So there is a debate which is going around the employers. Does this mean that every time I'm going to, for example, yesterday somebody has worked overtime, today also I need to have him work overtime? Do I need a consent every time I do it? Similarly, a women kind of, uh, one day you work in the night shift, the next day also she is required. Every time does she give her consent? And if that be the case, then it's going to put employers under tremendous pressure, because which means that what if the employee says that I don't want to work overtime today, or I don't want to work in the night shift today, because then I that's not an equilibrium, right? While it is true that the interests of the employees have to be protected, I think there is a need for the legitimate use kind of a concept for the employers under the OSH code. But having said that, to coming back to the topic, I don't think labor codes kind of overrides the right of the employee. Yes, there is a legitimate use, but if, let us say, a particular data is as an employer used for something that is not related to employment, there could be many. Let's assume the employer introduced, we all know, a car scheme, right? wherein they tie up with an NBFC. The loan is provided by the NBFC to the employee based on the fact that he's being employed with a particular employer. And for that reason, instead of the lendee, the bank or NBFC providing the loan, takes the employment information or employee's information directly from the employer. There is an handshake involved where employee's personal data is being handed over. I believe not for employment purposes, right? So, and if the employers are not careful and don't build in the required safeguards where whatever is the bank or NBFC app for which you are going to give a beneficial rates to the employee, etc., and that consent is not obtained, I think too many people are going to be involved in non-compliance with regards to DPDP Act. So from the perspective of labor codes, I don't think any provision in labor code kind of gives an opportunity for the employer to not to be in compliance with the DPDP Act, is how I will look at it.
No, that's right. That there will be a lot of interesting scenarios which will be coming out, in the coming days. So moving, if I will say again, given the factum that DPDPA is now almost a reality, of course, it has been deferred and will be implemented in a staged manner. And also the factum that the time to implement may also be reduced. So during the situation, how you are advising clients on social media screening of candidates? Is that now a high risk DPDPA violation, or what sort of safeguards you feel, yes, it can be done, but these safeguards have to be carried out? So what is the mechanism or how you take it? Isn't a gray area? What are your views on it?
Yeah, absolutely. So there is a lot of interesting possibilities. Probably from a social media screening and of a, let's say, a prospective candidate. That's when the social media screening happens, right? There is an aspect where the employee has willingly put it out on the social media. So if it is available for screening in public domain, I think we all know that there is definitely an employer has probably a right to know from where a person is coming from, what are his views, etc., to be very clear that from a cultural fit perspective, from a perspective, is he suitable for the position I'm looking for, and all of that will be there. So you really cannot bring in DPDP Act and then where the data is out in the public. But there are job boards and companies do a little bit more than that. They kind of rove around the job boards and then see what is the information that he might have provided to the job board, right? That job board would have taken the data on a consent basis, right? And that consent may not have involved somebody else kind of going under the radar and getting the data. So there are a lot of aspects there. So the job board, the recruitment support company, and the employer may be at risk there. So they need to be careful about what are they doing there and why are they doing it, right? And the employee can straight away question. So let's say he decides that I don't want this job, but then he comes to know that these guys have gone little more beyond what is required to get his personal data, and he has a fantastic tool on his hands. Right? So I think social media screening of candidates, employers should know how legitimate, how far they can go, but it is not always done by them. So it's also done by the companies that they have entrusted this job of recruitment. For example, there are these RPOs who are doing the screening and there are these headhunting companies who do the screening, and they all needs to know their limits and then how they are doing it, and is it probably they should do with the consent, saying that boss, we are going because we are considering you for this position, and are you okay with us kind of obtaining this data and sending it to everybody, is what I think overall employers have to be very, very careful about all of this. It looks for a serious rethink or a serious deep dive into some of these processes that they are doing, and they don't have much time. 18 months is already out of this 18 months, 3 months have gone by, 3 or 4 months have gone by for the DPDP Act to come
Yeah,
in.
that's very right. Madhuji, one interesting question always hampers, and in fact, I think you are also advising, we are also advising, I mean, I'm also advising, or almost everyone will be advising that looking to the DPDPA and labor code, which have literally, I mean, come at a time when both are in the phases of preparedness. Companies are gearing up to, I mean, implement both the core laws.
Correct.
So
Correct.
isn't the right time when the same documents are to be dealt or have to be screened, reviewed, and vetted or restructured, redrafted, whether it is a policy or the employment? So what you have to say, whether it is not a right time when simultaneously both should be implemented. Otherwise, you implement now for labor code, you bring changes, then again after 8 months or 7 months, again you test the same documents and carry out the implementation for DPDPA. What is your view on that?
Absolutely, it's very, very critical, and it's very, very good for employers that the kind of transition is happening at the same time. Labor codes are already effective, so they need to quickly move into that. And of course, they have time from a perspective of some of the data related requirements, like how do they maintain registers, how do they submit online returns to the government, how do they remit the contribution, wherein there are a lot of information which gets exchanged between the authorities of the employee. All that will have to depend upon the respective rules, which is going to prescribe the form, etc., right? Therefore, there is also time from that perspective. While it may be urgent for them to look at how the new wage definition is impacting their salary, and then because of which the cost of providing gratuity, cost of providing PF, etc., etc., they need to urgently look into it. But I think it is high time they really do this, particularly data related transitions into labor code in conjunction with the what is required from a DPDP Act perspective. Large employers, but any employer for that matter. The reason is, if you really look at it, government is going kind of all over the town saying that labor codes is enabling the government to do come up with a digital compliance framework, and they are repeatedly talking about it, saying that we will make everything digital. We want to enable the employers to uh, probably one single portal through which all employment related compliances can be done. And already employers are sharing a lot of this data over digital in the digital manner, like EPFO. Nobody is. I started my career at a time when we used to file all of this in a printed form, and we had to go used to go and give it to along with the check. We deposit it in the SBI box, and then we go and collect the same day. But I don't know, the employee data with all the details of this employee will be sitting in the SBI and, that box for days together after the chop up by the SBI that this money has been transferred, right? From that we have come a long way, right? And therefore, the it has to be very, very, very carefully thought through how this done. Particularly for compliance, most of the employers are reliant on companies who claim to be experts and in compliance, and like for example, TeamLease, RegTech, etc. And there are others like mom and pop shops who may not have the technology and the capabilities, and they use that ability of their knowledge, etc., and leave this data with them, right? What if the compliance service provider is not really equipped to take care of your interests, in the sense that the employee's digital personal data is passed on to this compliance provider, and he uses them to prepare registers, prepare returns, and all of that? But how is he keeping the data? Is it protected enough from a perspective that employer's responsibility in as a data fiduciary is respected and then provided for? Is going to be very, very critical. I think even a small employer needs to really think about that as a fact, as an operational requirement, that this data doesn't get passed between the compliance provider and the person who's responsible within the employer as to this data will be handled. It does not get exchanged between the by printed sheets, emails, and all of that, because emails it sits in somebody else. It should be kind of through system to system process, through APIs, etc. So if they are not careful in ensuring that transition, they may also, while there may be risk about compliance with the labor code itself, there
Yeah.
is a huge risk with regards to compliance to DPDP Act vis-a-vis the digital personal data of the employees. So going for, probably I have a couple of questions for you. So
Yeah, please.
from this discussion, see, labor code definitely has this lot of everything they're talking about is going to be digital. And how is, for example, I am sitting in the EPFO board, the CBT, and then they are very clear that they are an exempt from many requirements of the DPDP Act because they are a government authority or a public this thing. And we also know Puttasamy, etc., gives, and the other act gives the government and its institutions protection from a perspective, how do they handle? But even then, there is going to be a lot of other digital exchanges. For example, Industrial Tribunal government is talking about will completely automate the entire exchange, right? So which means that employee whose ever dispute is there being referred is going to happen through online this thing. So the authority is going to take this data and it is going to be digital personal data.
Right.
How do you look at government's responsibility in its ability to ensure the data remains private? What happens to, because the kind of data that ESIC, EPFO, the typical labor departments are all going to already sitting on them. In some of the states, even now, it is physical hard copy data being given about annual returns and all of that. And now, if it is online also, you really don't know where this data is sitting. It could be subject to hacking. Somebody can get into this and all of that. How do you view this situation? What are the protections that government has from a DPDP Act as a government itself in this context?
Yeah, that is the main. I mean, this will be again a very sensitive issue because the government has not come up with something whereby it can bind its employee, or the crown is always immune. That is
Yeah,
not reflected from every law.
right.
But having said that, definitely best practices have to be issued, and they should do it like in other parts of the world where
Right.
they are equally conscious. And I think because we are seeing pragmatic changes in India, even in the e-governance and whatever. And when we are talking about AI infrastructure, particularly and the e-governance, and definitely there will be some guidelines, regulation which may be coming in the future. But as of now, unfortunately, there are nothing to say, ki, look, they are bound by like that. Rather, there are many immunity what they are enjoying as of now. You rightly said there are many incidences in the past also. And in fact, in a normal organization also, and government is not alien to these things where the anything is coming out. So you never know what sort of protocols will be there, what sort of cyber security, how the mechanism, zero trust architecture will be deployed, in what manner. Maybe they are working on it. As we can make it out, definitely government is very serious on that front. But those type of guidelines are yet to see the sunlight, on the basis of which I can also say, okay, yes, they will be also doing like that in that manner. Having said that, I think all the portals definitely have a very good, I mean, they are very nicely managed. So
Right.
cyber attack and all other will definitely be tackled by them very diligently. But of course, there are no guidelines as such, to my information at least.
Yeah. I think the cost of breach is, I keep talking about cost of non-compliance on the labor codes is quite high because the fines are no longer 500 rupees, 1000 rupees. It's all minimum fine on the code of wages is 10,000 rupees, and the second offense is costing 20,000 rupees. But apart from that, in combination, the employee's data is what is going to be base for both labor code compliance as well as and the protection that the employer has to offer on the employee's digital personal data. Cost of non-compliance in DPDP Act is very high, right? We all know the maximum fine can be 250 crores, and we have some of our employers who are really big, right? And in the sense that some of them claim they're 650,000 people strong, etc. And in the range between 100,000 to 500,000, I think there are many employers today. And of course, they all are big employers. They have digital architecture. Probably they have considered all this protection and all of that. But they also have intermediaries who help them payroll process, compliance processing, etc. And if how do you look at the scenario that it will be a significant risk, and how from the top down, from the board listed company, for example, most of these big ones we are talking about could be listed as well, and top down independent directors, audit committee, risk committee, etc. How do you think that it should be looked at, and what do you think should be the priority, let's say, for an independent director part of risk committee in vis-a-vis DPDP Act?
Madhu, this is a very important question. Good that you asked today. See, there are different views to deal with it. But firstly, I will say the DPDP itself is a techno-legal enactment. The law itself talks about techno-legal.
Right.
But with the techno-legal, if I will talk as an organization or the business or industry, it will have a techno-commercial legal implication.
Correct.
So it is going to hit your bottom line. So now with this techno-legal law soon to be enforced by 13th May 27, it will be having a full-fledged operation implementation. So the companies have to really be very serious about it, that this will be a new business dynamics. The
Right.
business ecosystem will see a different working altogether. They have to connect the dot right from the manpower to the technology to the training and acquiring the skill set required to make a cope with this particular enactment. Gone are the days that, okay, these laws were not there, whatever you were collecting, whatever you were sharing, there was no accountability. But this law brings accountability. The first thing which organizations as well as independent directors or any board also has to see accountability. And this law itself talks about that it is evidence based.
Right.
If I will say evidence based, that means if you have taken a consent, you have to show. You
Correct.
have used for a specific purpose, you have to show.
Correct.
You have kept it secured, you have protected it, and the privacy was maintained. There are three words: privacy, protection, and security. So it
Right.
is your onus is on the organization to show that I have done this. And then if you are a significant data fiduciary, then there is an audit. You have to hire a DPO. The skill set will be also a very big problem. Another thing is companies are also thinking that, okay, we will have the best of the policies in place. We will create this. We have created this. We have deployed ISO 42001 also for AI. We have deployed 27,001 for data privacy. I mean, we are GDPR compliant. That's very good. I say that's very good that somewhere you are better than the others. But having said that, it is India.
Right.
You have to map firstly. There will be more reluctance, there will be more resistance. You have to see what are your business process. So I say three things. The KYD, know your data. KYB, know your business. KYO, know your operations. And having said that, what the three golden rules, what we have also released on this Data Privacy Day on 28th January, I will definitely reiterate that organizations will be guided by that. That means no data pollution, whereby you don't use the data, minimize data, don't over collect, respect data. You have to develop a culture whereby even you have best of the policies, but your mindset, your operation, you are not prepared, you are not trained. What you will do with those policies? Whether you will you will flex those policies to the DPP when any investigation will be carried out.
Right.
So
Absolutely.
that third thing is no lien to the future. The third rule is no lien to the future. That means don't encounter any situation where penalty will be imposed on you. The reason is why I say the third rule is no lien for the future. That means if there will be frequent or the subsequent breach, the quantum will be on the basis of your record also. So
Right.
these rules, if any organization follow, I think they will be carrying out everything what is ought to be done in the manner prescribed and how it should be done in an efficacious manner, because it is directly impacting your P&L, which I have to say at the cost of repetition. And the organization have to understand that now the trust factor, the goodwill factor, and the competitiveness will
Right.
be just, even the venture capital funds also, investors also will be looking at, in the due diligence also, they will be looking at how robust is your data privacy plan, implementation, what you have, the technical reasonable safeguard, operational reasonable safeguard, how it is in place. And any bad experience, that's why I say again, rule 3, no lien for future, any past incident. So these will be awakening for all of us. In fact, say if your data is breached or your data is compromised, you will not be willing to work with that organization. You won't be going for taking the services of that organization. But on the same footing, like NBFC or insurance companies, if they are taking good, I mean, the best practices, or and one more confusion arising, which is out of this particular question, is most of the people what they claim is, oh, we have implemented. How? That we have deployed best of the practices. Employing or deploying best practices does not mean that you are fully compliant with the requirement of the DPDPA. Or even if you are very well complied with the GDPR, you cannot be said to be complied with DPDPA. Even you claim we have mapped it thoroughly, we have implemented everything, we have vetted. And there is a one more problem which have to be seen by the board level. Don't implement in a piecemeal manner, because it's all about the starting journey to the end journey, data provenance, data lineage, and the data governance. So if you have taken the data, what is the journey, what is the process, and what was the fate of that? Whether the purpose is full, thereafter also, if you have kept it, why you have kept it. So everything has to be taken care of. Then only you can say, okay, even the board or the independent directors should also ask that at the regular intervals, because they are literally the custodian. So they can definitely ask as a neutral party that what are the measures you have taken. And in the board meetings also, they should be taking care of the best of the practices, and what thing should be avoided. They are also avoiding during the circulation or the mail, whatever communication exchanges. So this is, otherwise it is a very debatable and very long topic. Over to you, Madhuji.
Okay, so I think to overlay the topic on whatever you said in the last part of the conversation from the board perspective, what they look at it, all of this is also true when it comes to the employee data, which has been collected by them as an employer, where these people are on the board. And while the company where they're on the board might come and say that they have implemented DPDP protections, etc., and they might say it is all in the business processes, the one specific question that they all should ask the company where they are is that, have you done this with regards to the employees' data as well? I think that is the most important thing. That's where this interplay between labor codes and DPDP Act comes in, because you are looking afresh at how we are going to comply with labor codes. And the labor code compliance is nothing but all of employees' digital personal data. And you better be careful about it, and then put all these safeguards that Nanand is talking about from a DPDP Act implementation is the underlying thought process that we really wanted to convey in this fireside chat. And thank you for the fantastic discussion, and looking forward to further more of such discussions. Thank you.
Definitely, Majhuji, it was a pleasure to have interaction. The last line, what I will say is, that's why we always say the HR the CHRO or head are the second undeclared DPO of an organization.
Absolutely. CHRO is the digital data protection officer, particularly if they are a significant data fiduciary, which they can be in some of the companies are so big from an employee number perspective. Government might notify all such big employers as significant data fiduciaries. Then
Yes.
the level of responsibility, the level of care expected by a employer or the company is far higher than a normal data fiduciary. So that's even more important that employers watch out for what are the guidelines in deciding who is a data fiduciary, and if they are part of recognized data significant data fiduciary, then their responsibility is at a different scale, far higher than otherwise. Thank you.